Good morning, and thank you for joining us today. My name is Samantha Jessner, and I'm the presiding judge of the Superior Court of Los Angeles County. I'm joined today by the court's assistant presiding judge, Sergio C. Tapia II, and our court's executive officer and clerk of court, David W. Slayton. We're here this morning to highlight the results of a report the court released today, examining the first 3 weeks of available booking data after implementation of the court's new bail schedules, which became effective in Los Angeles County on October 1st. The new bail schedules, which include pre-arraignment release protocols, or PARPs, for offenses designated by law as non-serious and non-violent, provide for a pretrial release system in which the decision to release most arrestees from jail prior to conviction is no longer determined by a person's wealth, but instead by their risk to public or victim safety and their likelihood of returning to court. This is consistent with the constitutional purpose of bail, which is to ensure an arrestee appears for all court appearances and to reduce the risk to public and victim safety. To be clear, and contrary to popular belief, the constitutional purpose of bail is not punishment. Where traditional money bail amounts are determined only by the alleged offense, the PARPs now enable magistrate judges to also consider the person's criminal history and their individualized risk in determining whether release is appropriate. And despite what you may have heard, initial data unequivocally show the significant public safety benefits of this new approach. Findings from the preliminary data report released today show the new system is effective in protecting public safety. Low-risk individuals are generally being released. Medium to high-risk individuals are generally being temporarily held until arraignment. And rearrests for those booked in the last 3 weeks are minimal. And most who were rearrested were released in the first instance on traditional money bail, not the new PARPs, meaning they were released after being arrested for a serious or violent crime and were able to buy their way out of jail. And most of whom were rebooked for committing another serious or violent crime. I'm going to take this opportunity to provide a brief primer on the new system because it is imperative that all of us understand it. The new bail schedules and associated PARPs provide guidance to law enforcement as to whether an arrestee should be cited and released or booked and released. Released after a judge's review, a process known as magistrate review, or pursuant to existing law, released on traditional money bail after being arrested for a serious or violent crime. Or put differently, released because they can buy their freedom. It's important to understand that under existing law, offenses that are designated by statute as serious or violent offenses, including crimes like murder, rape, and robbery, are still subject to release on traditional money bail. To put a finer point on this, in these instances, when someone is arrested for a serious or violent crime, they can buy their way out of jail regardless of risk. The PARPs do not and cannot apply to serious and violent offenses. Rather, they apply only to non-serious, non-violent offenses. Recent headlines demonstrate the significant risk to public safety associated with determining whether someone will be released solely based on their access to money, rather than the risk they pose to our communities. Based upon widely circulating misinformation, we are taking this opportunity today to address these inaccurate and false statements, and will continue to do so. First, the idea that law enforcement is hamstrung by the PARPs and forced to catch and release individuals is false. The truth is, nothing in the PARPs prevents law enforcement from booking individuals at their own discretion. The law has provided law enforcement with this tool for decades. Similarly, the practice of law enforcement citing and releasing arrestees they evaluate as low risk is nothing new. This has been going on since well before the new bail schedules took effect. It's been going on for years. To be clear, law enforcement always had and continues to maintain the authority to book anyone into jail based upon their own exercise of discretion. Any statements or assertions to the contrary are simply false. In the interest of communicating accurate statements rather than false statements, I want to break this down for you. If law enforcement were to arrest an individual on the street for an offense designated in the court's bail schedules as cite and release, but they have concerns about citing and releasing the individual for whatever reason or reasons, law enforcement maintains the ability to book that individual into jail, to fingerprint that individual, and run a more comprehensive check of their criminal history. The notion that law enforcement has no authority to elevate offenses to be reviewed by a magistrate judge is false. The truth is, the PARPs include a process called bail deviation, in which law enforcement may request review by a magistrate judge if they have facts that would suggest the individual is an enhanced risk to public or victim safety or will not show up to court. This process existed under the old bail system, though it was rarely used, and it continues to exist in the new system. This is important because law enforcement often has additional information about an arrestee the magistrate judge does not have. This includes information about recent arrests that have not been formally filed as charges against the individual, which, to be clear, is a prosecutorial decision, not a court decision. It also may include particular facts about the individual's alleged crime and circumstances surrounding their arrest, and perhaps other criminal history outside of Los Angeles County. If law enforcement wants to request a magistrate review, all they have to do is pick up the phone and make a 1-minute phone call to the county's probation department, which operates 24 hours a day, 7 days a week, to request the enhanced magistrate review by a judge. Again, for emphasis, this process is not new. The idea that the PARPs discourage accountability for criminals is false. The claim that if you commit a crime, you will not be held accountable is dangerous and negligent rhetoric. The new PARPs are aligned with the purpose of bail, which is not to punish, but to safeguard community safety by relying on individualized risk assessments to ensure those who present the least risk to public safety and failing to appear are released prior to arraignment, and that others are released with conditions which will enhance public safety and ensure the individual appears for court. It is critical to remember that in our justice system, people are innocent until proven guilty. Whether a person is held accountable and manifest accountability is determined only after the person is charged, proven guilty beyond a reasonable doubt, and sentenced, not before. Under our new system, magistrate reviews are taking place 24 hours a day, 7 days a week, with magistrate judges conducting individualized risk assessments based on the offense the person was arrested for, along with their criminal history, and other information to determine the arrestee's risk to the public or victim safety, and their likelihood of showing up to court. Based on the individualized risk assessment, a magistrate judge can release the individual on their own recognizance, release them with non-financial conditions, or order the person temporarily held until arraignment if no release conditions exist that would protect the public or victim safety or assure the individual's appearance in court, regardless of wealth. The court firmly believes, and research and data support the conclusion that release determined based on these types of risk assessments, as opposed to arbitrarily releasing individuals based on how much money they can afford to pay, is much safer for the community and effective in protecting public safety and maximize returning to court. Based on early data, which David Slayton, our court's executive officer, will review in detail momentarily, there is no doubt that this risk assessment-based system is effective. Put another way, community safety is enhanced. Individuals subject to the new risk-based system are being temporarily held in jail before arraignment when they present a significant risk to public or victim safety or are unlikely to return to court, and released when they do not. Those who present a risk are being held based on risk and not based on whether they have access to money. I'm now going to hand it over to David to review the findings of the preliminary data report released earlier today. David.
Thank you, Judge Jessner. The court is committed to using data to monitor the new system to ensure it both protects community safety while at the same time ensures those who pose little risk do not sit in jail simply because they cannot afford traditional money bail. To that end, today the court released a preliminary PARP data report, which examines the first 3 weeks of booking data under the new bail schedules from October 1st to October 21st, 2023. Before I get into the details, let me start by saying that the court is committed to tracking data associated with this new system and plans to make available soon a data dashboard where the public can see for themselves how the system is working. Before that dashboard is made available, we thought it important to produce a report that examines whether the new system is operating as envisioned. And we are encouraged to report today that early data suggests it is. Where PARP is applicable, a shifting of sorts is happening, meaning the riskiest individuals are held temporarily prior to arraignment, and those who are less risky are being released, a significant public safety benefit compared with traditional money bail, where regardless of risk, you could buy your way out of jail. The PARP report examines 5,113 bookings that occurred in Los Angeles County between midnight on October 1st through 11:59 p.m. on October 21st, 2023. The average number of daily bookings during that period, 243, is consistent with the average number of daily bookings over the previous 12-month period. Note that when a booking occurs after an arrest, the law enforcement officer fingerprints the individual. This sample does not include those who were cited and released in the field by law enforcement at their discretion, or people arrested on an arrest warrant. It does, however, include people arrested for CR offenses who are nonetheless booked. Of the total bookings that occurred during the sample period, 14% were for offenses designated in the bail schedules as cite and release, or CR. 8% were designated as book and release, or BR. 27% were designated as MR, or magistrate review. And 40% were serious and violent offenses where traditional money bail still applies. 11% were other, which generally represents those booked for offenses that are not listed in the bail schedule. Of those who were eligible for a magistrate's individualized review under the PARPs, those that were CR, BR, or MR designated offenses, 55% of those bookings were ultimately reviewed by a magistrate. Under the new system, risk is now the determining factor as to whether and under what conditions those arrested for PARP-eligible offenses are released. And our data shows that in most cases, the right people are being temporarily held and the right people are being released, meaning those who present a risk to public safety and a risk of failing to return to court are generally temporarily held, and those who don't are released on appropriate conditions. During the first 3 weeks under the PARPs, 1,213 bookings were reviewed by a magistrate judge to assess the risk of the individual arrestee for the purpose of determining the appropriate release conditions for that person. 64% of those were ordered temporarily held until arraignment after the magistrate judge found that there were no conditions available to the magistrate judge that would reasonably ensure the safety of the victim or public or the appearance of the arrestee at arraignment. 85% of the individuals released under PARP were assessed as low risk. On the other hand, 71% of those temporarily held in jail for arraignment were assessed as medium to high risk. Disturbingly, 52% of those who were eligible for traditional money bail because they were arrested for a serious or violent crime were medium to high risk, all of whom could buy their way out of custody without any individualized determination of their risk. Presumably, many of them posted bail and were home for dinner, so to speak. As noted previously, the bail schedules and PARPs provide the option for law enforcement to request enhanced review through bail deviation for any offense designated in the bail schedules as CR or BR. When the request is made, a magistrate judge conducts an individualized review of the arrestee's risk in determining the appropriate bail for that booking. Data show that despite having the option to do so, law enforcement requested enhanced review only 133 times, or 3% of the time. In the other 97% of bookings, law enforcement did not request an enhanced review and permitted the bail schedules and PARPs to operate as written. As our report indicates, the court is committed to continuing to train law enforcement on this option. I myself have met with law enforcement groups many times over the past 3 weeks, and we believe with more training and understanding, law enforcement will know that this option is available to them. What the data does show is that the times that law enforcement does request enhanced review by a magistrate, they are doing so in appropriate cases. The magistrate reviews the information provided by law enforcement and other information available to the magistrate and has consistently found the need to temporarily hold those individuals for further review at arraignment. There have been repeated requests for the court to return to the old system, with many citing the potential for rearrest with the new system as a reason to go backwards. However, preliminary data shows that rearrests after initial booking, at least in the first 3 weeks, are very, very low, occurring less than 3% of the time. And importantly, about half of those rearrested were released on money bail, meaning they were arrested for a serious or violent crime and they could buy their way out of jail. Most of these were then rearrested for another serious or violent offense. This showcases the inherent danger of us relying on a money bail-based system that does not factor risk into deciding whether individuals should be released. Notably, only 2 of those individuals ordered released after an individualized risk-based review by a magistrate were rebooked during the 3-week period. In summary, initial data supports the court's recognition of the need to move away from a wealth-based system of pretrial detention to a system that relies on individualized, risk-based determinations to determine appropriate non-financial conditions, if any. As the report's key findings indicate, the PARPs enhance public safety by subjecting eligible arrestees to a thorough judicial review, which goes beyond what occurs with traditional money bail. For eligible arrestees, not only is a judge now considering the current arrest, They are also considering the person's risk to public safety and the likelihood that the person, if released, will show up for their court appearances. This results in release decisions based on reducing risk to public and victim safety and increasing likelihood of the arrestee appearing in court, not only on access to money. Money bail is antithetical to public safety, with the majority of those arrested and eligible for traditional money bail determined to be medium to high risk of committing a new offense, and oftentimes following through with that risk. Bottom line, the new system is working. The majority of those held temporarily after magistrate review are medium to high risk. The majority of those released after magistrate review are low risk, and rearrest rates for those booked are notably low. Judge Jessner?
The court is encouraged by this early data, which indicate the new PARP system is effective in protecting our communities and reducing failures to appear. Fundamental to the new PARP system is equal access to justice for all and the recognition that release decisions should be based on individualized assessments of an arrestee's risk to public and victim safety and likelihood of showing up to court, and not on a person's access to money. The court remains committed to working collaboratively with justice partners, including law enforcement, cities, and elected officials, to continue to improve the new system using data-informed decision-making tools and processes. The court remains hopeful that over time, leveraging the power of collaboration and data transparency, we will reinforce the inherent value of a pretrial release system that does not condition release on access to money, but rather on individual risk. We are now happy to take questions.
We will now take questions. We will now.
Hi.
Hi,
Can you hear me?
Aaron Halil, please ask your question.
Yeah, can you just talk a little bit more about the magistrate judge system? Like how many judges, how long do arrestees have to wait to see one, and where is this, thing happening?
So the court has a designated group of judges. They are judges of the court, elected Superior Court judges, as every other judge on the court. And those judges are ones who are conducting these reviews 24/7. They are assigned this function. They do so through a system that we developed where basically as soon as someone is fingerprinted, booked into jail, the information becomes available to them shortly thereafter. We provide a short period of time where law enforcement or the public can request that bail deviation process, as we talked about. And then once that period of time runs, the individual information shows up in the magistrate judge's queue for them to begin that review process. And that's basically the way the process works.
How many judges do this, and how long do they have to wait to see a judge?
Thank you. I think there are currently 10 assigned to that function. They are covering the every day of the week, all night long and every day. So there's about 10 judges who do that. And the time period that it takes for an individual to go before the magistrate review process is about 4 hours. Once that 4 hours runs, the process begins. Usually those reviews are happening somewhere in the 4 to 6 hour range.
Thank you.
Okay, let's go to Margaret Carrero with KNX.
Yes, hi. Thank you for taking our questions. I'm just wondering what you have to say to the many cities that have joined this lawsuit against the county with regard to the zero bail. What you have to say to them?
Well, one thing is we can't say is the Code of Ethics prohibits us from commenting on any pending or impending litigation, so we can't really speak today or at any point to the lawsuit. I think, regardless of sort of speaking to them, I think what the message from the court today is that it appears as at least so far that the the pre-arraignment release protocols that the court put into effect are working as we anticipated they would, and that they provide significant public safety benefits over the previous traditional money bail system that would have otherwise been in operation for these offenses.
Thank you, Margaret. Let's move on to Robert Green from the Los Angeles Times.
Thank you. Judge Jessner said that PARP cannot apply to serious and violent offenses, meaning that people who are charged with those offenses, many of them, except for those charged, I believe, with capital offenses, are still eligible to bail their way out. Why is it that PARP cannot apply to serious and violent offenses, or does the court have the option of extending it to those offenses?
Thank you, Robert. That's a great question. When the court was looking at this policy, we looked at where the law allowed changes to be made. And as was pointed out, the statutes passed by the legislature prohibit the court from enacting the pre-arraignment release protocols on the serious and violent offenses. So those individuals are required by law to have a monetary amount of bail set. So that is what the court has done. As you probably know, the court made no changes to the bail schedule with regard to serious and violent offenses, primarily because of that law. I would point out that there is still also individuals who are allowed to be held indefinitely in custody, denied bail, or so to speak, and those capital offenses and certain other felonies that are allowed to be denied bail based upon the Constitution or statutes are the category of offenses that fit in there. And again, no change was made to those either. Again, bottom line, the reason why these only apply to the offenses that they apply to, despite the fact that we believe they are working very well, we're limited in doing that to only the non-1270.1 non-serious, non-violent offenses based upon the law.
Thank you.
Thank you, Mr. Green. Let's go to James Quealy, also with the LA Times.
Sorry, I was on mute. I just wondering if you could also speak to, you guys have mentioned, the misinformation. There's been kind of a hysterical response to this. Looking at the data, I just want to see if you could talk more about the pie chart, total bookings by category, because unless I'm reading this wrong, 40% of the offenses that have been reviewed this month are traditional money bail offenses, and another 27 went before a magistrate review, which would mean basically 2/3 of the cases that have been processed by the court either went by the old system or at least saw a judge. So I guess looking at that data, it seems like the impact, or the quote unquote, the misnomer phrase zero bail, is not even impacting a majority of the cases that are being heard by the court. I guess if you could just talk about the scope of this and how the idea that people are being booked and released, unless I'm reading this wrong, the way I'm reading it seems to be that it's actually only impacting about 1/3 of the cases.
Yeah, that's James, that's exactly correct. The way you're reading that is correct. So out of the first 3 weeks, just over 5,000 bookings countywide, as you point out, 40% of them were still being processed under the old money bail system. They were serious and violent offenses where, in essence, they could purchase their freedom. They could pay for their way out of jail, as they always have been able to. As you point out, 27% of those individual bookings went before a magistrate judge automatically. So those were ones where the judges reviewed them pursuant to the new bail schedules. I'll point out that those same individuals would have either been released by law enforcement previously under policies of those law enforcement agencies, or they would have been eligible to bail their way out without any individualized review. So that's a new feature that we've added for public safety. And even if you look at the other three categories, the cite and release and the book and release categories, every single one of those bookings was eligible for magistrate review. So if law enforcement had a concern about enhanced risk to public safety or enhanced failure to appear risk, they could elevate those to a magistrate review. So again, I think from our perspective, we believe this provides additional tools to law enforcement. It provides enhanced public safety because the fact that, as you point out, other than those that are getting out on traditional money bail, we're seeing individuals who go before a magistrate judge for that individualized risk determination more frequently.
Thank you, James. Mr. Aaron from Courthouse News, I believe you have another question. Go ahead. Mr. Aaron from Courthouse News, are you there? Okay.
Sorry about that. I thought I was unmuted. I was just wondering if you could talk about the impetus for PARP, why it was instituted. Was it because of this Urquidy lawsuit and the injunction? And then also, my understanding is that PARP has already been updated a little bit. So maybe you could talk about that.
Yeah, thank you. Great questions. Just to be clear, of course, we can't speak about another pending or impending lawsuit. Urquidy is pending in our court, so I won't speak to that. But what I will say is that the process of really getting to where the court ultimately went in adopting these in July was based upon years of experience. In 2020, the court, pursuant to a legislative pilot program, the court implemented the beginnings of a risk-based assessment system, and had a couple of years of experience under our belt with that. That same system was evaluated by the state, the Judicial Council, and found that it was produced decreases in rearrest rates and increases in people showing up to court. So it had positive impacts. Then during the pandemic, of course, there was the emergency bail schedule that was put into place. And again, data shows that there was little to no impact from an adverse to public safety or failures to appear. Basically, it was no worse than what any system we had before, and in some cases, situations better. So based upon all of that local information, as well as looking at what other jurisdictions around the state and the country have done and the positive impacts they had with a risk-based individualized assessment, the court chose to take this action in July. As you pointed out, and as Judge Jessner mentioned when she announced this in July, the court is committed to continually reviewing the pre-arraignment release protocols to make sure that it is indeed working as we hoped it would. So far, we're seeing that. But as questions have come up, confusion, the court has updated the pre-arraignment release protocols and bail schedules as appropriate. So there was an amendment in September, another amendment in October. We refer to them as technical corrections. Generally, they're shifting of trying to make sure there's clarity in the bail schedules, but those changes have been made, and the court has said it's committed to continue to look at the data going forward to see if additional changes are needed.
Thank you, Mr. Aaron. Let's go back to Mr. Robert Green from the Los Angeles Times.
You spoke about bail deviation, that it's something that's always been available but rarely used. And in the last 3 weeks, it's been used a number of times. I wonder if the court has any kind of guideline for determining whether bail deviation is being utilized sufficiently, whether knowledge among law enforcement is sufficient about its availability. How do you determine whether you've achieved the goal of letting law enforcement know that it's available and that they're using it when they need to use it?
Yes, thanks. As the report points out, one of the things we note in there is that we feel that there may still need to be an increased enhanced training to law enforcement about the availability. We have no metrics as to X number should be subject to bail deviation, but in our conversations with law enforcement, it seems as if there's still law enforcement officers out there who don't know that that's there and that they can literally pick up the phone 24/7, make a 1-minute phone call and have that enhanced review. Like I said, it's been used 133 times out of the 5,113 bookings, so it's been rarely used. And it does appear when they're using it that it's in cases where there is an enhanced risk. Our magistrates have found that as well. So I think, part of the thing is making sure that individuals know that it's available. As far as when it's appropriate, the statute lays out in the Penal Code, California Penal Code 1269C, actually lays out the factors when enhanced bail review or bail deviation is permitted. And it's when a law enforcement officer has information that would indicate that that person has enhanced risk of flight or an enhanced risk to the community or victim or public safety. And so that's the information that law enforcement, when they have that available to them, they can use that to request the bail deviation. At the same time, members of the public under that same statute have the opportunity to request for a bail deviation downward, just as they always have. And I don't believe we've had any of those so far. The numbers are somewhat consistent with what we've always had. In the past, bail deviation was rarely used. I think it's being used more now than it was before because law enforcement used it about 10 times a month on average before October 1st, and they used it 133 times in the first 3 weeks of October. So it is increased, but it's, at least in our conversation with law enforcement, seems it's still an misunderstood and underutilized according to them method. So we're trying to make sure we get that word out to them.
Thank you.
All right, seeing no further questions, we will conclude the news conference. Thank you so much for joining. Have an excellent day.